Good morning, everyone, and thank you all for coming. It's very early hour these days for our first in-person seminar for quite a while, and I'm delighted to see so many people here. Although one speaker not here yet, but hopefully not too far away. Yes, just to introduce myself. First thing I need to say to everyone is this is also being recorded and is online to about 70 people.
Yes.
If you don't consent to recording, I mean, the camera's facing this way, so you won't be in shot for the most part, but let me know. I can't do anything about it, you'll have to leave, sorry. Yes, I'm Doug Robertson, partner in the Restructuring Insolvency team at Urban Mitchell. I've got Tom Patham sitting over there, also partner in the Restructuring team at Urban Mitchell. Tom's mainly Sheffield, I'm mainly Leeds, but between us we're sort of the northern powerhouse of insolvency, I like to think. And we have, I'm sure known to most, if not all of you, Eleanor Temple KC, who is going to also present this morning. So I will I'll move on to our first slide, which is us having done the introductions. The other person who's not here yet is Joanne Bone. She'll be presenting on data subject access requests, or DSARs. Hopefully, I've seen her presentation. I could give it a go, but I'm sure she'll hear it. So we're diving straight in then. My first is only a relatively small part, hopefully, is just a quick update on Avanti Communications, which was a case decided, I think it was last summer-ish, which involved a wholesale supplier of satellite communication capability. So basically owned a network of satellites and ability to launch satellites and licensed places on their satellites. And unfortunately, it went into administration. There was quite a complicated charging structure around Avanti and its debenture. It's a 2017 debenture. And the old question reared its head again of what constituted a fixed charge and what constituted a floating charge. And of course, this has quite a lot of significance these days in terms of HMRC's preferential status, and therefore, if we can argue more is subject to fixed charge, certainly from a lender's perspective or a debenture holder's perspective, it would be quite important. So if I actually follow the slide, Avanti purported to grant fixed charges pursuant to various debentures securing debt to its lender. Again, it went into administration. An application was made to determine whether the charges were fixed and floating because there were some unusual charging provisions. And essentially, if we drill down to where the number of the issue was, there was a number of exceptions to the fixed charge or to the debenture, which allowed Avanti to deal with its assets. There was the limited value exception, which does what it says on its tin. On the tin, I think if an asset's worth less than $2 million, it could be dealt with without restriction and sold. If it was less than 1 million, there was no restrictions on what happens to sale proceeds. If it was over $1 million, the sale proceeds had to be paid on to the lender on fairly onerous commercial terms. So it was a limited exception, and a company such as Avanti, there wasn't much subject to it, but it's important because below $1 million, the company was free to deal with its assets and retain the proceeds. The capacity exception related to capacity on the satellites and allowed satellites basically to be sold, not the satellites, but the capacity on satellites to be sold, and therefore allowed to trade in the ordinary course of business. The obsolete and usefulness exception, hopefully I'm not there yet, but is where things became old and obsolete and had to be replaced, and the company was free to deal with the assets that were obsolete and not useful. However, importantly, there were restrictions and important obligations to replace the assets that were dealt with in this way, so the security wasn't negatively impacted. I.e., if you get rid of an old satellite, you had to get a new satellite, and it was still subject to the debenture and the fixed charge, so it was almost in the lender's favour. And the license exception, again, was about the ability to license and trade in the ordinary course of business. Naturally, Avanti could license space on satellites, etc., and generate income without having to get releases from its lender. Essentially, there was an ability on Avanti to deal with its fixed charge assets, which was questionable whether or not that meant the charge had sufficient control following Brumark, etc., to constitute a properly fixed charge. Now, I'll focus on the limited value exception because the capacity exception and the license exception really were about trading in the ordinary course of business. And the example the judge uses is a fairground or a Ferris wheel, where if you sell tickets for a Ferris wheel, you can keep the proceeds from the tickets and you don't have to account to the lender for them, but the Ferris wheel itself could be subject to a fixed charge, and that's entirely consistent with the control. It's if you sold the Ferris wheel and then could deal with the proceeds, that becomes more of a question. So it's that sort of situation. The obsolete and usefulness exception, again, I don't see a problem with that being a fixed charge on the basis that the restrictions require the assets to be replaced with up-to-date assets with more value. So there may be a theoretical point about whether or not they could just dispose of assets and therefore you get fixed charge on the asset and floating charge on the proceeds, but there are also requirements in terms of using the money to either pay off the debt or replacing the equipment. Ultimately, the judge found that it was a fixed charge, despite the ability to deal. And the test he adopted was to look at the charge document and to determine the rights and obligations in respect to the charge assets, i.e. the ability of the borrower, the company Avanti, to deal with the assets, and then consider whether or not those rights and obligations are consistent with a fixed or floating charge. And again, we're going back to the Brumark spectrum control test, i.e. was there sufficient control of the assets? We're talking about bank account, blocked account, inability to use it in the ordinary course of business, etc., to render it subject to a fixed charge, or was the company free to deal with it in the ordinary course of business? Now, all that is relatively uncontroversial, but the one part of this that I find, I think interesting is the word, hopefully, but I find interesting is that with the limited value exception, you've got a fixed charge over an asset worth up to £1 million. But when you sell that asset, the borrower is allowed to deal with the proceeds. And for me, that doesn't feel quite right. That's going back to, if we go back to pre-Brumark spectrum, that's up to Renew Bullis. And yeah, if we go all the way back to Yorkshire Woolcomb, so the point, and the reason New Bullis, if anybody remembers it, was criticised, was there's a lot of, it found you could have a fixed charge over book debts and a floating charge over their proceeds. And there was a lot of analysis done both in court and academically to say, well, actually, how can you have a fixed charge over an asset where at the instance of the borrower themselves, they can collect it in and then take the proceeds? Therefore, it can't be consistent as fixed here because, and you get the proceeds there because there's not sufficient control. So it was ultimately, and this was the point of Brumark and Spectrum, it's found that you couldn't have a floating charge or a fixed charge over the book debt and a floating charge over the proceeds. It could only ever be a floating charge because at any point by collecting that book debt, you got rid of the charge and there was insufficient control. Similarly, and I'll go back to my Ferris wheel, if you've got a Ferris wheel that's worth less than £1 million, yes, I'm fine with you selling tickets and the money disappearing, that's okay. But when you can actually sell the Ferris wheel and the money disappears, you've again got a fixed charge over the asset and then a floating charge over the realisations. And for that reason, I do question whether or not the sort of move away from the orthodoxy in Avanti is actually correct. And yeah, I don't know if the case will ever be particularly considered as just first instance. But my view when advising lenders, IPs, etc., is treat it with a bit of caution. I think it's unlikely that lenders will find that it's going to expand the definition of fixed charges in administration situations. And certainly I've had conversations with a couple of clearing banks about it, and their legal teams have come to the same conclusion. So I hope you found that fascinating for 8:30 on a Thursday morning. Without
so Joanne was next up. She's hit some traffic, unfortunately. She's about 5 minutes out. So I don't know if you want to go to if Eleanor wants to go next.
Why not?
I was going to crack a few jokes. No, okay. Just get. We all know St. Joanne's. Is this your one here?
This is not mine.
Not yet. No.
Maybe just a.
What's it still on?
Which is not too late. There you go.
There we go.
And I won't amend the slide, although I did amend the badge to add those magic letters. Good morning. Thank you for having me here, and especially the first time speaking as King's Counsel. I'm going to talk to you about Good Box which is an interesting choice because it's a case that I lost, and I'm about to go to the Court of Appeal on it. And I'm looking for a bit of audience participation and possibly some feedback, market research, as it were, and I shall anonymise you for the Court of Appeal. But for those of you that have followed that case, it's interesting for a number of reasons. Firstly, it's the first restructuring plan outside of London. Anybody here been involved in it? I don't think so. I've checked. I think there's nobody online either. And also because it involved an SME. But there were various quirks with that case. If anybody's read it, you will have seen. The first challenge was that the company was trading and there was nobody to fund the trading. So the initial skirmishes between the former administrators and the company were over how this company could keep standing up in order to get it into a plan. And you may have seen that Mr. Frost, one of the administrators, wasn't terribly keen on the plan either. And so when the approval hearing came on, and the decision was made on Valentine's Day, actually last year, by Malcolm Davis White, the judge was pretty critical of the administrators' attempts to thwart the plan as a consequence of funding issues, and said, well, that's a matter between all of you and I'm not going to get involved with it, and indeed dismissed the administrator's application for directions in relation to how much the company should fund him to carry on with the administration pending the plan. And some say that's a particularly harsh decision in circumstances where what were the administrators supposed to do, where they had a bid for the assets of the company, not very much, about $500,000 in the background, and a plan that seemed to have various holes within it. At that initial stage, the joint administrators didn't oppose the restructuring plan, and I should say that I didn't deal with the approval hearing, another barrister did. The judge took their non-opposition neutrality, as it were, as being a little bit unreasonable, and indeed made a costs order against them. So they didn't have a good day out from the start. And some of the commentators that have looked at the terms of that plan have been a little critical in terms of the reasons why it proceeded in the way that it did. And Walker Morris, I think, acted on behalf of the plan administrators, although now do not. And after the initial skirmish about whether or not the company should be in a plan or not, and the position of the former administrators, there was a dispute brewing in the background about the former now administrators' remuneration. And that situation is not dissimilar, you will have seen it in your own practice, to a company that's in administration and goes into liquidation, and then there may be a dispute between former administrators and liquidators as to the prior remuneration. And there was a case a long time ago involving Mr. Maxwell called Brilliant Media, which was also my case. So I seem to get involved in these fee dispute cases, although I had a baby on that one, and Lisa Wormersley, who's now in the BVI, did the hearing. And I actually saw Bob at my Silks party last week. He came all the way to Manchester. So it was obviously a good case in the end. And that, if you recall, was the case where a company was in administration but moved to liquidation. And there was a big dispute between the creditors and the administrators about how long Mr. Maxwell should stay in office during administration. And initially, the creditors had wanted to limit his period in office to 6 months. And the administrators said, well, no, we've got things to do. We don't think 6 months is long enough. We think we should stay in for the best part of a year. And so a dispute arose between the administrators and the creditors about that. And in the end, the administrator agreed that the company could go into liquidation. That left open a number of disputes in relation to fees. And crucially, in Brilliant Media, which will feature in my skeleton for the Court of Appeal that's going in during the course of the next couple of weeks, the creditors had approved remuneration on a time cost basis. So they'd fixed the basis on a time cost basis. And you'll all be aware of how you fix basis time cost, fix some percentage of realisations. And that's all a matter of public record at Companies House. If I hadn't been involved in it, I would have been able to have found those details should I needed to have looked for them. And a remuneration application was made. I think at that stage DLA were acting for the administrators, and they made an application under the forerunner to Rule 1823 of the 2016 rules, so Rules 2106 and 2108 of the 1986 rules. And what those rules allowed the court to do, and now do through 1823, is to fix the basis of remuneration. So just bear in mind that expression. And when that application comes on in front of Registrar Jakes in London, the creditors have approved the fees for the first 6 months, fixed the basis, time costs, approved the remuneration for the first 6 months, but won't approve any remuneration beyond that because they say, well, Mr. Administrator, we said you should have left office, we didn't want you in. And Mr. Maxwell says, well, it's quite irrelevant what you think because I think I needed to be in. So the judge has to determine both that issue as to whether or not he's entitled to any remuneration at all, and the applicants say also, can you fix the sum? And then there was a side piece, although that became the forefront of the judgment, as to whether beyond the period of administration, when the administrator was doing work to assist the liquidators, so no longer an administrator but still carrying out work, an administrator was entitled to be paid as an administrator for remuneration during that period. So no surprise that in relation to that last issue, the administrator lost, because what the rules say is an administrator is entitled to be paid for the time that they are the administrator. And to the extent that there's anything else to be paid for, then that's purely a contractual matter between the liquidators and the former administrators. In relation to that second period of time, first period of time, part of it had been approved by creditors. Second period of time, an application to fix part of the first 6 months plus the second 6 months, the court said, well, you're an administrator, you're entitled to be paid. That's rule 1, isn't it? And what I'm going to do is I'm going to conduct effectively an assessment based upon challenges from the liquidators pushed by creditors. And the court set about assessing what was a fair and proper amount of remuneration, taking into account the insolvency practice direction, and those sums were fixed. So park Brilliant Media and move on to Good Box. After the plan was approved, or during the approval hearing, there was a discussion with the judge about, and I know this from various people, because this was a case where people were listening in online, people who were not instructed in the case, lawyers and indeed others. There was a discussion about what would happen to the former administrator's remuneration, because in that case, there was a fixing of basis on a time cost basis under 1823, and there was an agreement that the administrators would only take the sum of £235,000 on account. And the reason for that was that at that stage, that's all there was available out of realised assets, and it wasn't thought that there would be very much more. So the resolution read, remuneration fixed on a time cost basis. Administrators have approval to draw £235,000 as a payment on account. And once the company goes into a restructuring plan, as you know, the term of office of the administrator ends. And so what Judge Davis White did was add a recital to his order that nothing in the restructuring plan would cut across the administrator's entitlement to apply under the rules to fix their remuneration. But nobody at the time gave any thought to which rules they were going to use in order to deal with remuneration. It's not expressed, and neither does it appear on any of the transcripts. And so after the approval hearing, there was a provision in the restructuring plan, clause 8.3, that also said the same thing. Administrators not prevented from making an application under the rules. But otherwise, all claims for remuneration of the restructuring plan were subject to a complicated adjudication process, which for any of you who've seen plans is not dissimilar. Company moves into the plan. Not a great deal of love lost between the administrators or indeed the former directors. One of the former directors is now employed, I think, as a plan administrator or Good Box restructuring plan administrator, but not obviously as an office holder. Buckler Phillips are in as plan administrators. The administrators through their solicitors say, well, we think you've got more assets in your hands than we had previously realised. And although we said we'd only take a payment account of 235, we've actually got the best part of 500,000 on the clock and we'd like some more money. So they go off to the plan administrators, and the plan administrators say, no, there's no creditors committee anymore. There are no creditors to approve your remuneration. You only have approval up to 235. So you have to make an application to court. And they tell the administrators to make an application under rules 1824 and 1828. Rule 1824 and 1828, or Rules 1824 and 1828, are the rules that allow a change of basis, an increase in amount, or a change in the rate. And if you've ever looked at this, probably no reason why you would unless you found yourself in this position, you'll see that there is a set of procedural rules that deals with increases in amount where you exceed your fee estimate. And that's pretty straightforward. But in this case, there was no exceeding of fee estimate. The administrators were within fee estimate. And so my predecessor, I should say not me, drafted an application under 1824 and 1828, consistent with what the plan administrators had told them to do, there being no other rule that would appear to fit. And the reason I mentioned Brilliant Media at the outset was that Brilliant Media used the forerunner to 1823, which was the rule that allows the court to fix basis. And although the judge was very keen on Brilliant Media, it seems pretty obvious to me that Brilliant Media was a case where the basis was already fixed. So that rule didn't work either. And it won't be a surprise to anybody that the insolvency rules often have gaps and they don't work, because that's what's kept me in business for the last 24 years. So this application starts live, and we go in front of Malcolm Davis White, and he says, I'm going off to Newcastle because I'd rather sit up there. So I'm going to give it to my learned colleague, His Honour Judge Klein, who many of you will know is a property lawyer, not an insolvency lawyer. So that was the first hurdle. And I am then instructed, I think, to seek to rescue the position because the administrators have already had a costs order and various other things against them. And we turn up at the first hearing in December last year, and the judge says, well, how can these administrators make this application? Because they are former administrators. And the rules say an administrator can make this application. And for about the first 5 seconds, because for those of us that do this work, we know that it means we can make the application, but it's a bit like an elephant. How do you describe it? And I'm looking at the judge saying, well, there is a provision in Schedule B1 that says if the context requires, you can read in former to the words administrator. And he says, well, you show me a case where that's been done. So I say, well, Brilliant Media, because that was a case where somebody was an administrator and the company goes into liquidation and they're not an administrator anymore, and they make an application under 2106, which is the same as 1823, to fix remuneration, and the court does it. And the judge says, well, Ms. Temple, that's very interesting, but the point wasn't argued because nobody took the point that former administrators couldn't make this application. So I want you to show me a case where somebody has argued that a former administrator can't make the application and has been successful. Well, my lord, I can't do that because everybody just knows that you can do it, and therefore there is no case. So he adjourns it off for points of claim, which, of itself was bizarre, for me to explain why it is that a former administrator can make this application. And in between that and the next hearing, I get all the authorities out that show that a former administrator can make the application. And I mean, there are lots of instances where this has happened. Lehman was a case under paragraph 98, where the point was taken as to whether or not former administrators could make the application. Court decided that they could. Obviously, Brilliant Media, and there are other cases like that. And we go along to the next hearing, and I think the judge is a bit disappointed that the point that he thought was a really good point about former administrators is not a good point anymore. And he's going to have to find for us on former administrators, not least because the whole point of going along to get remuneration fixed is so that the court has control in circumstances where otherwise there's no procedural route and the plan administrators are not going to assist the former administrators. And remember, rule number 1, administrators and other office holders are entitled to be paid. So it's a good example of where, when somebody who doesn't do the work gets all at sea, when they pick up an insolvency case and they don't necessarily understand what we're all trying to do. Anyway, so far so good. Judge is with us on former administrators, and indeed is now interested in Schedule B1, paragraph 111, that allows a former administrator to make the application, or a application where the context requires. We then move on to, a former administrator can make the application, but I've had a look at 1824 and 1828, and those rules allow somebody to apply to increase the amount, change the basis, or change the rate. And Ms Temple, I don't think your administrator clients are doing any of those things, because what they're asking for is an increase in the creditor approval payment on account. And that's not a fixed sum because it's a payment on account, and you've already got your basis fixed because it's a time cost basis. So this happens in the hearing with no warning. And I say to the judge, well, hang on a minute, in Brilliant Media, there was a fixed time cost basis was fixed, and the court still fixed remuneration. So, you know, why can they have an answer and we can't have an answer? And the judge says, oh, well, I have the answer. In Brilliant Media, and this is the comedy point, which hopefully will find favour with the Court of Appeal. And in fact, I should say the judge gave me permission to appeal against his own decision himself. And that's only happened twice in 24 years. So I think he knows where this is going. But anyway, he says, well, in Brilliant Media, it's obvious, the answer is obvious, that what happened was the creditors only fixed the basis on a time cost basis for 6 months. And so that's why the judge was able to use 1823 or the forerunner, because what he was doing was fixing basis for the second period of remuneration that, as I told you earlier, hadn't been fixed. And, you know, what I said was, well, judge, go and have a look at what it says on Companies House, and we can all look, because it says fixed cost basis, administrators are making the application because the creditors will only approve a certain proportion and not approve all of it. Where is all of this going? There is a lacuna in the rules, it seems to me, and if anyone has a view, I'd be delighted to hear it, in that there doesn't appear to be a procedural rule that deals with the issue of time cost basis being fixed, remuneration being incurred within fee estimate, and creditors only approving a certain sum. And in the ordinary course of events, either the creditors would challenge, and there's obviously a procedural route for them doing that under the insolvency rules, or if you hadn't agreed to get creditor approval, or you hadn't agreed a payment on account, if you had a time cost basis, my view is you just take the money and let the creditors challenge. But because there's no way of taking the money, because the company's in a restructuring plan, we can't get our hands on it, similar to Brilliant Media, there has to be an application made. And so where we are at the moment is the judge in his judgments, and if anybody's bothered to read it, I'm not suggesting that you do, because it's not, you know, it's certainly not my favourite reported case. It's not a good advert for Leeds BPC Insolvency Business Centre. But anyway, I wrote to the judge. I've never, ever done this in 24 years. When the judgment was handed down, I wrote to him in between, more or less saying, please don't do this. This is a disaster. There has to be a mechanism to assist office holders. Please list it for further argument, because you can't do this. You can't just dismiss this application in terms. But what I actually said was, go on Companies House and reread the progress reports, the decision of creditors and the final progress report in Brilliant Media, and you will see it was a time cost basis fixed generally. I mean, I don't know how many times you've ever had it fixed for a period. I've never seen it. But you're misunderstanding what happens in these cases. Please list it for further argument and consider alternatives, i.e. filling in the gaps. And there are authorities that say that where the insolvency rules don't provide an answer, the court can, probably should, fill in the gaps, because we all know it's unsatisfactory legislation. And there's also inherent jurisdiction. And the judge flirted with that in his judgment and said, oh, well, it might be inherent jurisdiction. Where we are at the moment is I have permission to appeal to the Court of Appeal on whether or not the judge has construed rules 1824 and 1828 correctly. And I'm also asking for permission to appeal on procedural grounds, because the idea that this is raised in the middle of a hearing about a point that the judge has raised that he's decided he's wrong about, without proper time, and no skeleton arguments on these points, because the points were raised in the hearing. But also whether, if he has construed it correctly, whether the mechanism is something else, be it inherent jurisdiction or judge filling in the gaps. Because one way or another, there has to be a mechanism for administrators who have been ousted because of a restructuring plan or because of a liquidation to have their remuneration fixed and assessed and fixed. And if he's right, Brilliant Media is wrongly decided, and all of the other cases where the courts have intervened in a similar situation are wrongly decided. And so the first argument that I'm going to run is, and it's not that sophisticated, but is we went along and said, we've been given the best part of, I think we had 219 out of the 235 in the plan administrators. And although it's not a fixed sum basis, it's still a sum. And we want to increase the amount. And there's nothing within 1824 and 28 that defines what the court means by amount. And what the judge has done is he's conflated 1823 with 1824 and 1828. He said, well, 1823 talks about time cost basis, fixed sum, percentage realisation. And so 1824 and 1828 must be the same. So when you talk about changing basis, well, that's just changing those three things. When you talk about increasing the amount, that must mean increasing the fixed sum. And when you talk about changing the rate, well, who knows what that is? Because that could only be an hourly rate. And I think you can see already that the two don't sit beside one another. So I'm going to say he's construed it too narrowly. We're applying to increase the amount. There's no reason for not letting us do that. And even if it's not a neat fit, use a purposive approach to construction and give us our order. And the huge irony is that on the issue of former administrators, he agreed that he had to use a purposive approach to construction, and he had to construe administrators, including former administrators, while they were in office, because otherwise there was no procedural mechanism for an assessment. And so that's the first argument. The second argument is procedural, as I've said. And the third argument is, if the rules don't work, please tell us how we can make them work, either by the court using inherent jurisdiction or by filling in the gaps. Because if restructuring plans are going to be a thing, particularly in SMEs, which remains to be seen and at the moment seems to be unlikely, there has to be a clear route, because the next time I get involved in a restructuring plan, particularly if I'm involved early doors, there is absolutely no way that the question of the administrator's remuneration, if the company's been in administration first, is going to be left to a recital that says go use your powers under the rules without any indicator as to which rule, and then a bun fight between the administrators, the plan administrators and the directors of the company, which is what we've got now. So this shiny new restructuring tool, which is supposed to be usable by SMEs in good box, has been, so far a little bit of a failure, because there has been so much money spent on arguing about funding the trading whilst the restructuring plan is put together. Administrators being told off for having had the gall to argue about it. And then this fee dispute that is running on, causing everybody to run up costs, whilst the court identifies how it's going to assist the administrators. And so it's crying out for the Court of Appeal to deal with it. And I thought it would be of interest in case any of you get involved with it. I think the good news is, as I said in my submissions when I asked for permission to appeal, one way or another, these administrators are going to get an assessment of their remuneration. And as I said to the judge, it doesn't matter how it's achieved, they are going to get it. And I say you should have given them that route in the hearing and not dismiss the application. And of course, we've applied to stay cost orders and all the rest of it so that we can go off and appeal. So it's going to have to be resolved. The Court of Appeal are going to need to resolve it. But it's worth just bringing to your attention the wording of those rules and how they might not be a particular neat fit in case you find yourselves in that territory. But also, even in a liquidation situation, it's worth just flagging that if you got somebody difficult, they may try to upset all of those prior authorities that we've all relied on, assuming we can use them, Brilliant Media being one of them, on the grounds that if you were to read Good Box as against Brilliant Media is wrongly decided. And so that's another reason why the Court of Appeal has to intervene. So there we are. I don't know whether anybody has any views. If you have, I'd be delighted to hear them now or afterwards.
I had a couple of things just on it. One is Owen Mitchell. I think Begbie's wasn't involved in the first and only successful SME or mid-market restructuring plan. So I'm sure Canal's on the line there somewhere there. So yes, there are people who've been involved in mid-market restructuring quite successfully. Down to circumstances, no doubt. The second thing is I agree completely about the cost position, because we've had it on at least one matter where we've had to apply to set the basis before the 18-month period expired, following which you can't apply.
Yes.
Set the basis or had the application stayed, but when it came to actually determining the amount of the cost, the court was pushing to say, well, set the basis, but not the amount. Now, luckily on our one, there was only secured creditor being paid out, so an agreement was reached.
Could be reached, yeah.
But absent that, there was going to be that gap there. So it's something to be aware of if you're making the 18-month application to avoid running out of time.
Yeah, and did the judge give you a solution, or was it just left that
No, we
you had a solution?
Yeah,
so
because we had creditor approval, we did it on paper, and it was BPC was this week. Leeds Business Property Court, and it was this week. But again, we had the creditor saying we agree.
Yes.
And I was going to look see who made the order, but I don't think it was on a judge client.
Right. Okay. I mean, it's interesting because if you look at the Insolvency Practice Direction, I mean, as you can probably imagine, I don't like losing, so this has kept me awake many hours, and I won't lose in the end. But if you look at the Insolvency Practice Direction, whoever's written that obviously thinks that the court has the ability to approve sums of remuneration, and not just in the context of a creditor challenge, because otherwise the Insolvency Practice Direction would say, when a creditor challenges the amount of remuneration that an office holder has drawn, these are all the rules. It doesn't say that. It says on a remuneration application. And if all you could do was fixed basis, all this stuff about how you assess the amount, a bit like a cost assessment in litigation, wouldn't be there. There'd be no point. And the Insolvency Practice Direction itself draws a distinction between fixing basis and fixing the amount too. So whoever wrote that seemed to think that it could be done. But in fact, in fairness, the only fair thing I will say about that judgment is it isn't clear cut, and it required somebody sensible to say, I've got two warring office holders, I've got creditors and a company in the middle. All the office holders want is me or a district judge, I was asking for a district judge to do it, to go through the time records and say, you can have that. And then you can ask the plan administrators for it, and they can say yay or nay, we've got sufficient assets under the paragraph 99 charge. And he just wouldn't do it. So, I mean, that is nonsensical in the restructuring climate and in terms of being office holders, because, we go back to office holders are entitled to be paid. So there is some sense for what happened in terms of it not being clear cut, but no sense for what's happened in terms of assisting our community. And query whether or not anybody will issue one of those in Leeds if it's not resolved. So that it's important that it's sorted out. So watch this space.
Well, I can add to the slight glumness on that, because we've had one in London recently. And we had to make a real decision as to whether we did it in Leeds or in London, and we thought we'd do it down there. We had a group we wanted to fix. We had a creditor that for some reason wasn't going to engage, and the IP, this group of companies, had this beautiful fee proposal where it would be a mixture hybrid of fixed fee, percentages, and time costs. And their actual fee estimate was less than what it would have been at pure time costs. And the judge in London looked at it and said, well, this is all very good, but what happens if you sell the properties for, say, double that you're projecting and what your valuer thinks? You could make an absolute windfall here. I have a real problem with this. And so we said, okay, so what would you prefer? And the judge said, well, could you just do it on time costs? So we'd spent ages doing this beautiful thing. So it wouldn't be sort of, usually judges hate time costs because they think it's, not creative and it's not adding value. And on this one, they sent us away and said, no, come back and I'll give you it on time costs. So I think across here, a bit cynical about the way these are dealt with.
Well, that's another interesting point, because the criticism in Good Box was that my predecessor, who had drafted this application, had decided to pitch it for whatever reason. I think it was because the plan administrators told them to use these rules, and he looked at the rules and thought, well, I can't see how this quite fits. But he'd pitched it on the basis that the administrators had a fixed sum agreement. But if you read the resolution said costs are fixed on a time cost basis with the payment on account. So it definitely wasn't that. However, we did try to ride two horses for a while, and that when the judge took the point, because you could say, well, you had a time cost basis plus a fixed sum of 235, because you obviously can have more than one basis. But the problem is, where was the justification for the 235? I mean, you've got to give all sorts of costs information if you look at SIP 9. I mean, that's another piece of useful commentary in terms of why we shouldn't be where we are in Good Box. But I mean, I agree with you. I mean, it's nonsensical to have this sort of open-ended time cost basis where you could have some other some other form of basis. And the whole point is that the court's supposed to take control. And particularly, in administration, how many times have we heard the judge has general control over an administration? And so that would have been a better way to control what was going on with fees and time cost basis. So there we are. But it will get resolved. And there's a very, very good judge in the Court of Appeal, who I'm sure will be very interested in it.
Super. So I'm conscious time is moving on, and we now have Joanne with us, unless you've got any comments on the insolvency cost regime. No? Okay. So, and
anybody got the answer? Because if anybody has the answer, I'm quite happy to share my brief fee to the Court of Appeal.
No, okay. So Joanne is a partner in our commercial team who has a particular interest in GDPR, if I can put it that way.
UK GDPR and GDPR. Get with the times, do.
Hence Joanne being here. So I'm just going to skim back to Joanne's slides.
Liam, do you know how to make it cooler in here? Because it's like an absolute. It's
I'll do it. Right, there's your slide. Let me
Shall I crack on while you press random? Good morning, I'm Joanne, and I'm in the commercial team. And as Doug said, my thing is data. Anybody had a DSAR, had to deal with a DSAR? Yeah. Was it fun? Everybody enjoy it? Complete pain in the backside? Yeah. We are seeing more and more DSARs. People are using them to essentially try and find out information, try and use it as a stick to beat people with, try and leverage settlements. The ICO has this interesting view that people make DSARs because they're interested in what's happening with their personal data. That is not the case at all. People are using it. As I say, they tend to be thinking it's so painful to deal with, we can get what we want or we can get early discovery. But the ICO's view is very relevant in terms of what their approach to DSARs is and what your approach to DSARs should be. Because as I say, their very quaint view as to why people make them colours how they deal with them. So I think it's useful talking about what an actual DSAR is, because I think a lot of people that make them and a lot of lawyers that make them is the random button pushing that word. Yep.
Usually it does.
I was going to say typical bloke, not read the instructions. So I think it's useful to understand what a DSAR is. I think it's useful from your point of view, but I think it's also useful for batting them off, because a lot of lawyers don't know what a DSAR is. So I see them a lot where we've had some letter in, and what they're asking for is a lot of corporate documentation, as I said, trying to get early discovery. But a DSAR doesn't give them access to corporate documentation. A DSAR is access to that individual's personal data. So board minutes, things like that, unless it's about them, unless it's biographical of them, that's not in it. And I think one of the ways that we bat off troublesome DSARs regularly is to say, yeah, we'll do a DSAR. This is what you get it. And all this other stuff that you've asked for is not within the scope of a DSAR. So they're entitled to their own personal data. Personal data relates to an identified or identifiable living individual. Anyone that's dead does not have data protection rights. It's a bit like defamation. The thing about identified and identifiable, identified is relatively straightforward in terms of they give you a name or something, identifiable. So we do see sometimes people come to us and go, don't worry, you don't have to deal with the DSAR because we've not named them. So it's a bit like Voldemort, they don't name who it is. So it is either the borrower or the employee or whatever it is. Obviously, if you can work out who they are from the file that they've put all the stuff on, then they are identifiable. So that doesn't really work. And we do see that a lot. So that's pretty much a non-starter. As I say, it doesn't entitle people to business documents that are not about the individual.
Would it be easier if I?
Yes, it would.
Just-
Thank you.
I
At least I
don't need to
can-
read it, do I?
No.
No, okay, sorry.
Yeah, you don't need to be there. And in terms of what you have to provide the information that their personal data. You don't have to provide documents, interestingly. You have to provide the personal data. So in actual fact, if you've got a document that there's a very little personal data and the rest of it is not about them, you could just extract it. You don't have to essentially redact it all because it looks like something out of the Second World War in terms of, you know, eyes only and stuff. So you can extract it, although the ICO aren't keen on that. But the other thing that has to be provided is a privacy notice, because I think that tends to get overlooked, but there's a whole list of other information that should be provided. So I think the key thing in an insolvency situation is who is the controller. The obligation is with the controller. And there has been case law around if a company is in administration or in liquidation and a DSAR is made, who has the responsibility for dealing with it and whose obligation is it? And essentially, the distinction was drawn in the Southern Pacific Loans case that essentially it depends. So essentially, if the DSAR is made to the company, then it is the company and the company is the controller. So it decides what data is collected and how it is used. Then it is the company that responds, and the responsibility of the insolvency practitioner is as agent of the company to deal with it. So it is not an obligation on the insolvency practitioner or the firm. If, however, the insolvency practitioner is acting as principal rather than agent, and they receive the DSAR, then it is their DSAR. And that's important because if you don't actually do what you're meant to be doing, it's who's going to be fined. So generally, if it is the company,
Suspecting just the principal role, an agent will apply in bankruptcy possibly and in receiverships, but not having in the liquidation, just with supplementing that.
cool, thank you. Can I supplement yours as well as we go on?
Don't mind.
Well, that's because I was late.
This could be a rough half an hour.
Thanks, Doug. No, I mean, it is relevant, and I think sometimes it's a bit esoteric in terms of when you think about it in abstract. So yeah, no, that is helpful. So I think that's worth bearing in mind, and I've just put Cambridge Analytica on the bottom. Cambridge Analytica is it's a wealth of information, to be honest, from a DSAR data point of view, insolvency point of view, in terms of what happened. And I'm not going to go through all the points that were raised in Cambridge Analytica, but as you'll remember, Cambridge Analytica, micro-targeting, election campaigns, Brexit, all fell apart because essentially there was a whistleblower and then people pulled the business because they didn't want to be associated with Cambridge Analytica. A US academic put in a DSAR, and Cambridge Analytica failed to respond prior to going in to administration. So he then carried on pushing it, and he was supported by a number of lawyers and was clearly being bankrolled by privacy campaigners. So he pushed it, and the easy answer out of Cambridge Analytica, because the liquidator said we don't have to do anything. Was it in liquidation at that point? I think it was. We don't have to do anything, and referred to Southern Pacific Loans. So the first point is the court said Southern Pacific Loans is right. Depends who the DSAR is related to. Is it the company, or is it in relation to the insolvency practitioner as principal? So that's easy. The other approach that they had taken, though, was that the ICO got quite angry about the fact that the DSAR hadn't been responded to and had issued an enforcement notice against the company. And the liquidators turned around and went, well, it's against the company, or the administrators, can't remember at which point now. It's nothing to do with us. We're not going to deal with it. And that went to court. And the decision was, it's not directly, the enforcement notice is not against the insolvency practitioner, it's against the company, but you should have done something with it. You can't just ignore it, because even if it's not something that the liquidator, it's against them personally or against a firm, it is against the company, and it does have to be dealt with. So that did have to be dealt with. There are some other things around. You don't have to, once you go into a company as an insolvency practitioner, look at previous breaches of data protection. You're not required to interrogate what has happened before to see whether or not you want to go off on a frolic and fix it, which I think is quite helpful. And there's some other bits and bobs in it, but it is quite an interesting case from that point of view. So I think that's the sort of one of the things that we do see a lot in terms of who has to respond. And I think drawing the line as to whose responsibility it is to respond, and also whose responsibility, or who's likely to get fined if you don't respond, is quite important. Having said that, in terms of if it is a DSAR that needs to be picked up, then essentially it's worth knowing that it can be made in writing, it can be made verbally, it can even be made in social media. If I was ever going to make a DSAR, I'd do it on social media and just see what happened. So I think it is worth, you know, having procedures to pick those sort of things up. You can't make people fill in a form. People try and make them do things like that. Also, the thing now is that you might get something that's generated by the ICO. So people can now fill in a form and then you get an email from the ICO, which causes panic, because in actual fact, it's just a DSAR. But, you know, as you can imagine, getting an email from the ICO tends to cause panic in terms of, are they going to fine us? What's going to happen? Is there going to be enforcement action? So I think it's worth, you know, taking a step back, reading it, and it may well be just another DSAR. You can't charge a fee. You used to be able to charge a fee. You can't currently charge a fee. And you essentially have to respond to a DSAR for free, which obviously causes a lot of problems. You can charge a fee if it's manifestly unfounded or manifestly excessive. You can also refuse to respond to it if it's manifestly unfounded or manifestly excessive, which we will have a look at. I will tell you now, it is not easy to convince the ICO that it is manifestly unfounded or manifestly excessive. They don't like it. Verifying identity. You should have a process, if you get one, as to verifying the identity of the individual if you need to. Obviously, if it's somebody and you know exactly who it is, you don't need to verify identity, but you do need to verify identity if you're not entirely sure that the person making the DSAR is who you think it is. It has to be proportionate, but it is important because there has been a case essentially where through a number of DSARs, somebody got hold of enough information to then start identity theft. So that I think they started out with something like Spotify and went through fairly gentle things to get little bits of information, and then essentially collated all that information and then ended up being able to do identity theft. So you don't want to fall foul of that, obviously, if you are dealing with them. One thing that's useful to know is that the time does not start until you have identity. Time scale is a calendar month. It's not 28 days, it is not 30 days. I see this all of the time from other lawyers. It is a calendar month. And there are all sorts of ways that you can work out in terms of if it's a bank holiday on the response date, but essentially it shifts to the next working day, but it is a calendar month. Requests made on behalf of individuals. I think the key one here is solicitors. A solicitor who is acting generally for an individual does not have a right to make a DSAR on their behalf. They have to give authority to make the DSAR and also to receive the results of the DSAR. So if you are getting a solicitor that's getting bolshy about stuff, you need to, they don't have authority without specific authority in relation to the DSAR. We do see sometimes things like parents and spouses, but I suspect you won't see that too much. Sometimes spouses think that they've got the right to get information on the other half, which they do not. Timescales for responding, as I say, it is a calendar month, but it can be extended. So if the DSAR is complex, it can be extended. You can't automatically say everything's complex. I do have a client that reckons every DSAR they get is complex, but it isn't. So complexity will look at things like, is specialist legal advice required? Are there a lot of exemptions to apply? How hard is it going to be to do it? If you If you are able to establish complexity, then you can extend the time limit for responding for up to another 2 calendar months. So you can get up to 3 months, which is quite handy. If you're going to do that, you need to send the data that is easy to get within the month. So if, for example, somebody's asking for something and some of the data is dead easy to get hold of, it's in a file, so it's an ex-employee or something like that, you can essentially provide that within the calendar month, and then anything that might be trickier, you can extend if it's complex. But the ICO like to see you send something within the calendar month, because they don't generally agree that everything is complex, and it would be unusual for everything to be complex. There are some ways in terms of to extend time in addition to complexity. As I say, verifying identity, time doesn't run until you've verified identity. Checking authority of solicitors, again, time doesn't run until you've got authority. And the other one is clarifying the request. You are able to clarify a request. Do not say narrow, use clarify, not narrow. It doesn't go down well with the ICO. And for clarifying the request, if you get a DSAR, which we see, and it's like all my personal data from the last 16 years, particularly if it relates to an employee or something, and it's like brilliant. So what you can do is go back to say, is it in relation to a certain set of people? Is it in relation to a certain subject matter? And the position is, and the reason why it's useful for people to actually clarify it, because we usually send the kicker, which is, if you don't tell us what it is, we might not find the stuff that you're looking for, and we only have to carry out a reasonable and proportionate search. So people tend to clarify at that point, but it pauses time while you're waiting for clarification. Unfortunately, people tend to come back quite quickly, so it doesn't buy you a lot of time, but it is worth thinking about. And as I say, complexity extends time. As I've just mentioned, it's things like, is the data archived? Is there a lot of sensitive data? Have you got to think about exemptions? Volume of data itself doesn't make it complex, but volume of data added to those things helps you argue complexity. One thing we do see from a complexity point of view is people say, well, I'll ask them for an extension then because it's complex. It's like, no, you don't have to ask, you tell them. It's for them to not like it and go to the ICO. And it's unlikely that the ICO will interfere, not least because, you know, by the time that the ICO have sort of kicked into gear and sort of come back to you, you probably got to the end of the additional 2 months anyway. So, do you know what? As I say, clarification, you can clarify, it shouldn't be an automatic response. And if they don't clarify, then you carry out a reasonable and proportionate search. And what is reasonable and proportionate depends on resource, how difficult it is to get hold of the data, is it all archived, things like that. So if it's a very small business, and you've got very limited resources involved in the insolvency, then you know, you can argue that that is going to be essentially disproportionate to do a wide-ranging search across all the archive material and things. So that is something that's also worth thinking about. Manifestly unfounded and manifestly excessive. As I say, the ICO don't like it. And one of the things that I would say to you is play nice with the ICO. We see people that write very aggressive letters in response to DSARs to the data subjects, and also very aggressive letters to the ICO. Not a good idea. The one thing I will definitely say to you is play nice with the ICO. They get quite angry if you don't. And also, I think it's worth bearing in mind that the ICO understand that DSARs can be quite challenging, notwithstanding their quaint idea that people are just trying to find out what personal data you hold. And I think you need to look super reasonable, because some of the other people that will send them ranty letters will not look super reasonable. And therefore, you sort of start occupying the moral high ground, and then they start to think, well, is this person being unreasonable? So our approach is always, right, a very, you know, even if we're sort of ghostwriting to go back to the individual, is write a nice, balanced letter, make yourself look reasonable. In terms of manifestly unfounded, it's essentially that there's no real interest in getting hold of the data, that they're using it to leverage a settlement or something. So the ICO has guidance, and one of the things on it, as you'll see, is essentially trying to gain a benefit from the organisation, so trying to leverage a settlement. Unfortunately, most people aren't stupid enough to write to you to say, I'll withdraw my DSAR if you pay me £10,000. I mean, you can read between the lines with a lot of DSARs, and you know that's exactly what they're saying, but that's not what they're saying, unfortunately. So it's quite hard to make manifestly unfounded fly. Equally, if they're being malicious, if they're targeting a particular member of staff, or so if they're targeting a member of your staff or something of that nature, then essentially it's something to bear in mind. Equally, if they're doing it systematically to cause disruption. Manifestly excessive essentially is a similar sort of thing, that they're doing it systematically to cause a problem. So the fact you've had 2 DSARs won't make it manifestly excessive, but it will start to add up, obviously, the more you get. And we did have somebody that sent a DSAR every week. And it's like, for Pete's sake, honestly, what do you think the data that's been processed in the last week has been? But obviously at that point, when you get a lot, you can start arguing that it is manifestly excessive. In terms of acknowledgement of DSARs and searches, essentially, as we've talked about, play nice letter, manage expectations. If you want to clarify, if you want to argue it's complex and extend, it's worth dealing with that early doors. The other thing that we deal with early doors in the acknowledgement is playing back to them, particularly if they've sent a very wide request, to say you're not entitled to business data. So explaining they're entitled to personal data, they're not entitled to business data. It's quite useful to do it at that point rather than in the final response. And the reason to do it early is it gets it into their head and it gets it into their solicitor's head. If you do it when you finally send it out, then sometimes people, as I say, kick off. Because they think they're getting an awful lot of really useful information, early discovery, and then they're not, and then they get angry. So I think how you deal with a DSAR early is quite important. You have to carry out a reasonable and proportionate search. You have to think about how they would be referred to within the organisation. So if names, nicknames, and some of the nicknames are interesting. Initials, so we use initials within the business. Obviously, if I were making a DSAR, I would ask for my 3 initials as well as my name for the business, and other relevant identifiers as well. Because the other thing we see is, don't worry about it, because all the sensitive stuff, we put it under their employee number, so we don't have to find that if they make a DSAR. Well, if you know you're doing that, or the business has done that, then yes, you do, because it's an identifier. So a lot of wheezers that people come up with don't actually work. The one you want to pray you don't get is a CCTV request. CCTV requests are a nightmare. We see them if somebody's suffered personal injury and they may be wanting to make a request to a manufacturing business or something of that nature, because you are not meant to obviously provide third-party data. It is that person's individual data. So the ability to pixelate CCTV, sometimes you can send still images, but the ICO don't like. CCTV is a nightmare. The one thing I'll say about CCTV is that what we say to people is you shouldn't hold it for too long. Essentially, you should have a rolling deletion. And if that rolling deletion is 48 hours, 7 days, other than if an incident happens, then that will make your life easier.
It's like Boris Johnson's iPhone then.
Yes. Unlike Boris Johnson's iPhone, you are meant to have a retention policy applying to your CCT, unless of course he'd actually got anyway. So you can evidence to the ICO that you've not just deleted stuff, because obviously you are not allowed to just delete stuff if you get a DSAR. And I have been asked that in terms of, will they ever know? And I'm like, well, you just told me you're going to do it, so thanks very much for that. It is actually a criminal offence to do it, so probably best not to do it. data that is due to be deleted. So what I've just said in terms of if the data is there and it's not due to be deleted, you can't just delete it, you know, have a bonfire sort of Enron shredding style thing. But if, like CCTV, it is scheduled to be deleted when you receive the DSAR, you can continue with that scheduled deletion. So it is worth bearing that in mind, because people get very anxious about continuing with their deletion schedule if they have had a DSAR. The thing that is difficult, however, and I suspect it would be difficult in an insolvency situation, is archive data. Technically, archive data needs to be treated the same as live systems, but in terms of a reasonable and proportionate search, I think it's one of the things to consider. The other thing we see is that people get a DSAR and then they continue to save the data after the date of the DSAR, and then they try and send out all the correspondence or emails between people to say, oh, we've had a DSAR from so and so, what should we send? Should we send this? I think we should send that. That is not right. You stop at the point the DSAR, if they want all of that information, they have to make a second DSAR. But certainly it feels like, because as I was saying, it means you'll never stop, because your DSAR will never have an end, because you'll constantly be creating stuff. There are exemptions. They are set out, as I was saying to Doug earlier, it is now UK GDPR within the UK and the Data Protection Act 2018. They work in conjunction with each other. The exemptions are set out in the Data Protection Act, and there are a lot, and they are very complicated, and they have a lot of caveats to them. Common ones that we see are third-party data. Essentially, the right, as I say, is for individuals to access their data. It's not the right to get other people's data. So that if it will involve the disclosure of third-party data, there needs to be a consideration as to whether it's reasonable to disclose it without the consent of the individual. If it is not, you need to either get consent or you need to redact. Privilege. Privileged material is not disclosable under a DSAR. Privilege, as you'll appreciate, is not the easiest topic. It is not my specialist subject. Where we see a problem arise is if it's applied differently in response to a DSAR and in response to litigation. Because if things are disclosed under the DSAR and are then argued as being privileged in disclosure, people then start going, well, why didn't you disclose it? And then vice versa. So we have seen complaints to the ICO as a result of that. And we've also seen complaints to courts as well, in terms of what we got it on the DSAR. So I think the one thing that I would say is if you're going to apply privilege to a DSAR and there is ongoing litigation, it is worthwhile making sure you take a consistent approach. When you send out the response, you need to finalise redactions. We use, essentially, we bake them on with Adobe in terms of their redaction tool and then finalise it. If we're feeling particularly paranoid, we'll then print it off and photocopy it again and scan it back in. It depends who it is, because sometimes the person making the DSAR, you really don't want them to get hold of some of the stuff if it's privileged or whatever. So what you don't do is use a marker pen and then photocopy it, because you can obviously read through it, and we have seen that happen. Or Tipex, although I don't think Tipex is widely available these days. I think I'm showing my age. You need to send out a covering letter explaining what you're sending, that you're not sending business data, what exemptions you have applied. You need a record of exemptions as well. What you don't need is you apply them and then forget what you've done, because if they complain to the ICO might come back and go, well, what exemptions have you applied and why did you not provide that? And if you can't say why you didn't supply it, then the ICO obviously are not happy. In terms of how you respond, there are rules that essentially, if you receive the DSAR electronically, you respond electronically. If you get it in a letter or verbally, you can choose how you respond in a commonly used format. But if you are going to respond electronically, don't just attach it to an email and send it. It needs to be sent via some secure method in terms of like a data room, or it needs to be encrypted or whatever. We have seen people complain to the ICO because some very sensitive information, including medical information, was just attached to an email and sent to them. If you send it hard copy, obviously it needs to be tracked. What I'll say quickly in relation to DSARs is they are a focus of the ICO. They're a focus both in Europe and in the UK, and the ICO is ramping up what they're doing about DSARs. Having said that, you have to be pretty bad for the ICO to take enforcement action. Quite often, if you've not done what the ICO think you should do, you'll get a letter from them, say you've got 2 weeks to sort it. Get on and sort it. They did take enforcement action against a council that was taking 2 years to respond to DSAR, so they didn't like that. So that was a London council. And the other people that they did take action against, which is one of my favourite things from an enforcement point of view, is the ICO kept phoning them up and then they could pretending they weren't there, like they'd pick up the phone and then go, hello, this is the answer phone of so-and-so or whatever. So they constantly refused to talk to the ICO. They sent their letters back saying not known at this address when they were clearly there. The ICO didn't like that and did take enforcement action. I thought it'd take some balls to do that, to be perfectly frank, but you know, each to their own. The one thing that I would say to you is if you can't meet a deadline, is send what you can and say when you're expecting to send the rest of it. And then if they get on the high horse and go to the ICO will just go, well, send it when you said you'll send it. And the final point is data protection reform. It is on the cards because evidently Brexit was all about taking back control of data. And therefore we have to reform our data protection laws. Obviously, nobody that voted for Brexit was that interested in personal data laws, but, you know. There is a Data Protection and Digital Information number 2 bill. It was sailing through Parliament. It is now bogged down in the House of Lords. In view of where we are and when we're likely to have a general election, I'm not sure it will now happen. So I'd just flag it. I probably, I don't know, as I say, this time last year I would have said to prepare for it, think about what you need to do. Now I probably would just wait and see, because I think it probably will die a death were I a betting man. And that is the end, unless anybody has got any questions.
Thanks for that. It's just clarification around, I understand the personal commercial is fine. I get the loan, but it's going to fine. Individual trading in his own name, and then you've also got a partnership situation where there's personal, but usually more than one person.
Yeah. So sole traders and partnerships are treated as individuals. But there's still the point that if it's about the business rather than about the individual, it's not their personal data, because there has to be a biographical element to it.
It gets really blurry though.
Yeah, I know it does.
When we speak, you've got partnership. But everything is personal and the business is all mixed up.
I think
it'll be mixed up in a partnership with other people.
I think it is, but I think there are lines drawn in terms of some of the stuff that is purely business. As I say, there is this biographical nature to it. So it's not just data relating to an individual. It's got to be about the individual. So if it were about the running of the business and not them, then provided that you're comfortable that it's about the business and it's not about them, then you can say it's not your personal data. I completely take on board. It's great. But the other thing I would say to you is, if you're not sure, is send them what you think and do a documented rationale. Then if the ICO come knocking, if you've documented the fact that you tried to do it right and they tell you you're wrong, they're unlikely to take enforcement action. All they're likely to do is to say, actually, we disagree, send out the information that you've held back. And I think that's always the way to deal with the ICO. If you document the fact you've tried to do the right thing, even if they disagree with you, they're unlikely to take enforcement action.
what is the enforcement action?
So enforcement action can be a fine, it can be an obligation to respond within a period of time. The problem with enforcement action is that it is public knowledge, so they will issue a press release. We had 2 clients recently that was subject of enforcement, not as a result of any advice we gave them. They came to us afterwards. One was a very small company in Leeds, and they had the BBC at their door because they were on the ICO website, and we thought it would just go under the radar because nobody had ever heard of them. But yeah, they had the BBC at their door. So yeah.
And presumably in the insolvency context, it would be against the insolvency practitioner.
Well, you see, the enforcement, if it's a non-compliance by the company, then it would be the company that would get the enforcement action. And it's back to the agent principal point.
Yeah.
If it's the insolvency practitioner acting as principal, then they would be the one that would get the enforcement action. So it's a bit like Cambridge Analytica, because it was the company that had ignored
Yeah.
the ICO. It was the company that got the enforcement action, although the insolvency practitioners were told that they would acted incorrectly in ignoring the enforcement action, because as agent for the company,
Yeah.
they should have dealt with it.
So there's a risk.
But if you're the ICO, you'd probably be arguing that that fine is going to be at the expense of the liquidation or admin and ranking ahead of the office holders' fees. So reputationally and financially, probably just still as bad.
Yeah, and I think, but one of the things you can argue, Tom, and I've seen this argued as well, in terms of if there is enforcement action, and this is slightly going off piece, but if there is enforcement action, the ability to pay. So they have to take that into consideration in fixing the amount. So what you might find is that they take enforcement action in terms of doing it and naming and shaming, in terms of sort yourselves out, but the fine may not be that big. Although having said that, you can't just wind up a company to deliberately avoid enforcement action, which also has been suggested by people.
Excellent. Thank you. I'm conscious we've only got 5 minutes left. I don't want longer.
I'm going to wrap up in less than that, Dodgy. I'm not going to keep people between them and the next caffeine. So, yeah, thank you very much, everyone. Eleanor, we really appreciate you coming in today to present that. Fantastic. We'll keep our fingers crossed for you at the Court of Appeal. Joanne, thank you very much for UK GDPR and everything that comes for that for IPs, and Doug as well, last but not least, on the Avanti case. Rebecca, have we got any questions online? No one wants to share Eleanor's Court of Appeal?
I'd really like an answer.
Any questions in here for anyone we've not covered? Okay, fantastic. Well, really appreciate everyone joining us. I think in total we've got just over 100 people that have been with us either online or here today. That's great. Looking at where people were from, obviously a few from Leeds here today, but I think the record in the south was someone from Plymouth who's logged on and wisely not driven up today. And I think the record from the north was someone from Teesside, so we've got really good geographical coverage. A little bit about the market, just really briefly. I think everyone's saying this at the minute. It's a bit of an unusual market. I don't think it's quite found its level yet. The corporate side, there's obviously lots of smaller CBLs that have been out there for a couple of years, but I think the general wind is that perhaps the larger businesses are going to need some support this year, and we'll all be involved in that, no doubt. The personal market is also a little bit suppressed, but the latest we're seeing is that HMRC are taking a lot more of a bullish approach on that, so we think that's going to change as well this year. We're coming up to our year end, but notwithstanding it's been a difficult year perhaps for the market, or an interesting year for the market, I'm delighted to say that we've grown on turnover, so that's fantastic to see that growth. We're also really pleased to share that we have a new colleague with us this week in London, Jack Foster, so welcome Jack. We have some further recruitment planned for this year, so watch that space, this space. But I think perhaps one of the reasons we're seeing some growth, and it's a shameless plug in a way, but as well as having a great R&I team and great colleagues like Joanne, who have their specialist areas that we can pick up the phone to and work with, we've taken a little bit of a different approach within our R&I team, in that although we will all cover core areas, we also have some genuine specialisms. So we never dabble in unusual areas. We have specialist people who do that a lot. And we work very much on a national basis, and we're very joined up, and that's really helping us, and we're seeing some good results from that. So we look forward to continuing working with everyone else. I hope you have a great end to the week. If it is your year end coming up, we hope it's a nice smooth run in, and all the very best for that. And we'll see you all soon. And for those of you that want to join us for another coffee, you're very welcome to.
Super. Thank you for that. And yes, again, thank you to those online and those in the room. Excellent. Thank you.